Good day, Crime Talk aficionados. We have a great show for you. First, the Bryan Kohberger matter. The judge's orders have set the stage. Next, the Karen Reed retrial begins today. This one's going to be good, experienced, good attorneys. Scott Peterson is still trying to get a new trial. School should not be Fight Club. And you know what? Teachers, you can get charged if you allow it to become one. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and check us out on any of your favorite podcasting apps. Before we get started, I'm going to remind you to go to crimetalksearch.com. You can sign up for a background subscription service today, and when you do, you can do a background search on anyone here in the United States. The report is literally prepared while you wait, and you're going to get all types of information. For example, emails associated with the person you're searching, social media presence, phone numbers that they're associated with. So, if your husband has, all these extra email accounts that you don't know anything about, could that be because, he's signed up for his Tinder account or something? I don't know. You may want to go check it out. And you're going to get to find out whether somebody has a criminal history, whether they have liens, judgments, are they married, are they divorced? Everything you want to know about somebody that maybe they're just not telling you. Go check it out. Sign up for that background subscription service today. You're going to be happy you did. And remember, you can cancel at any time. All right, let's go ahead and get to the show today for Tuesday, April 22nd, 2025. And first on the docket, the Bryan Kohberger case. Yes, the case that just keeps on giving. And I go back through and I look at the judge's orders, and I'm telling you, the stage has been set. And it provides more insight as to where this case is going. First, the prosecution's case rests on several key pieces of evidence, right? And the judge's rulings have significantly shaped the trial. First, we got the DNA and the digital evidence, denied motions to suppress the DNA from the knife sheath, cell phone records, email data, surveillance footage, and Amazon purchase rulings allowing or ordering that they were all lawfully obtained under the search warrants and the third-party doctrine. And we got the roommate's testimony. The judge allowed in DM's testimony about seeing the masked man. The ruling issues should be addressed via cross-examination, not via exclusion. Then we have the autism diagnosis issue that the court ruled on, prohibiting the prosecution from mentioning any ASD type displays to explain demeanor unless Kohberger testifies, but allows the defense experts for rebuttal. And then, of course, we have the alibi as it relates to the nighttime drives. Is there really an alibi? Well, the judge is going to give him a little more time to come up with it, kind of like that third-party alternate suspect. You would think after 2.5 years, if there was a solid alibi, which we now know there is not, the defense would have put it out there. If there was a viable alternate suspect, that would have been presented long before now. The judge is still giving the defense a little more time to do so. But the reality of it is it doesn't exist, ladies and gentlemen. And of course, we had the ruling as it relates to the use of the terms touch DNA, contact DNA, and trace DNA, potentially limiting the prosecution's narratives. Now, the bulk of these rulings favor the prosecution, obviously admitting critical evidence while limiting defense strategies, particularly around Bryan Kohberger's various diagnoses. The DNA evidence, a pivotal piece, is the DNA match from the leather knife sheath found next to Madison Mogen, with DNA from trash at Kohberger's family home in Pennsylvania. And obviously that is a big problem. And people can say, oh, it doesn't mean anything. It could be there. It could be whatever. The reality of it is unless you can say, and this is from, 30 years of criminal defense work. When one of my first big cases I ever did, I was still in the military, DNA was still just kind of coming about. We had hearings, whether it was even reliable enough to come in. And now obviously you don't even have those. It's been scientifically accepted by the courts. And they just lay the appropriate foundation. It comes in. But I've done lots of cases, including cold cases. And unless you can explain, and this is my experience as an attorney, unless you can explain how that got there through, i.e. consent, you would expect his DNA to be there because it was his house. It is a problem. And there's a lot of people that want to ignore this little piece of evidence. Oh, it doesn't matter how it could have got there. It could have been planted. Okay, prove it. How was it planted? Who planted it? And that's what people don't seem to get when it comes to this stuff. What I love about the true crime community is people are so engulfed in the case, but sometimes they pick sides and they ignore all the evidence. And like I said, I've said this before and I'll say it again. It doesn't matter what you believe. It only matters what you can prove through legal and competent evidence. So what evidence is going to come in to suggest that this was somebody else's knife sheath, or the knife sheath was Bryan Kohberger's, but it was stolen? And somehow the real killer planted it there just to frame Bryan Kohberger. You can make that argument. I could make that. I could stand up and do it right now. But the point is, what evidence do you have to back it up, ladies and gentlemen? That's not enough to raise reasonable doubt in this particular situation. DNA is the biggest problem for the defense. I've said this too. This case has been going on. You have to be able to explain it, because guess what? A random jury is going to look at this, and the prosecution will argue, what are the odds that Bryan Kohberger's DNA just happened to be on a knife sheath that we know that he bought, that the sheath was there at the house with his DNA on it? And we also know that he may have tried to purchase yet another sheath. Can't just make that go away. And what are the odds, ladies and gentlemen, right? I think I've told you, I've had this one since the summer of 1988 when I went to boot camp. 37 years, I guess it is. 37 years. I was able to hold on to and keep track of my K-bar for 37 years. And not your DNA wasn't on the little button, nor was mine. Bryan Kohberger's was. And it's to the point that the defense isn't even arguing about it. If the defense had an expert that was going to say, no, that DNA is not it, they've all but conceded the DNA is Bryan Kohberger's. So how are you going to get around that? It's going to be very, very difficult, ladies and gentlemen. And frankly, I'm not sure how that is actually going to take place for the defense. Then we have the eyewitness testimony, right? The surviving roommate, DM, described seeing somebody that she described as about 5'10" or taller, athletically built male with bushy eyebrows, dressed in all black mask the morning of the attack. Judge Hilper ruled this testimony is absolutely admissible, and that if there's any issues relating to the reliability of it, it can be addressed on cross-examination. Now, we've seen and heard in the court's orders what those summaries of the testimony was, and there's certainly things that you can attack about it, but if she didn't go out of her way, even after she had seen the arrest of Bryan Kohberger and said, oh yeah, that was the guy, it's definitely the guy. She's like, I don't know, I didn't see it. So that almost lends some credibility to it. Now, can a defense attorney have a heyday with that witness on the witness stand? Absolutely. It could be a brutal cross-examination if that's the way the defense wants to handle it. Or you just treat the witness with kid gloves and say, let's face it. It was dark. You were drunk. You were tipsy. You didn't know if you were awake. You didn't know if you were dreaming. Not a whole lot of reliability in that, right? And she may actually concede, you know what? It may not be reliable. I'm just telling you the general description that I have, and I added a couple of things, but I remembered it. It still goes to the credibility of the witness. We'll see. Then we have the surveillance footage, right? And vehicle evidence. The surveillance captures this white Hyundai Elantra near the crime scene, identified as Bryan Kohberger's, with his license plates changed 5 days post-murder. The car was found at his parents' home during the arrest, strengthening, obviously, the link that it is his particular car. Then we got phone records, right? They ping near the victim's residence there at 1122 King Road at least 12 times since June of 2022. Not saying he committed a murder on those particular times, but why was he there? Was he going to parties? Was he at that house all the time? Who knows? Did he carry a K-bar with him all those times? Did he lose it in the woods and somebody having to bring it into the house that night? Have to have good, reasonable explanations for this. And then we have the video, including twice on the murder day. The car was detected post-killings between 9:12 and 9:21 a.m. The judge allowed these recordings in, ruling them completely lawfully obtained. Then we have the Amazon purchase history, right? Records show Kohberger purchased this K-bar knife sheath and sharpener back in March of 2022 and searched for K-bar knives days after the murder. The defense sought to exclude this, arguing that the algorithm influence was improper, but the judge denied the motion, allowing it to come in, assuming the prosecution can lay the appropriate foundation. Then we got the selfie post-murder. Selfie taken at 10:31 a.m. on November 13th, showing Kohberger smiling and giving the old thumbs up. Obviously, it could be used to show his bushy eyebrows at or about the date of the murders. Maybe a state of mind thinking, I'm going to get away with this one. I mean, who did he send the picture to? He just happened to take a photo that particular morning saying thumbs up. So obviously the evidence in favor of Kohberger's defense has presented limited direct evidence of innocence thus far, focusing more on obviously procedural challenges and an alibi, and then obviously the possible alternate suspect, which there's been no evidence, at least credible evidence, up to this date. Now, the alibi, Kohberger claims he was driving alone south of Pullman, Washington, and west of Moscow on November 13th to hike, to run, to check out the stars, a habit he often follows. Now, the defense, through their expert Cy wants to use this to corroborate this alleged alibi that the defense is trying to proffer, arguing his phone did not travel east towards the crime scene. However, the prosecution challenges this, and the judge's ruling haven't addressed its admissibility directly, but the cell phone records are more than likely coming in. And the defense theory, I mean, they can say it doesn't show that that his car moved further east because it was simple. It's simple because his phone was turned off. Obviously, the prosecution is going to argue because he thought he was going dark so that he could go commit these murders. Obviously, the defense sought to exclude the Amazon click history, arguing it could be taken out of context, and the roommate's description of the bushy eyebrows, claiming prejudice. Judge Hippler denied those motions, allowing these pieces of key evidence to come in. There are procedural arguments, not direct evidence of actual innocence. And then the whole autism spectrum disorder. Defense claims he has extreme rigid thinking and little insight into his behaviors, potentially affecting his demeanor in court. They argue executing him would violate the Eighth Amendment. However, the judge ruled the evidence is completely irrelevant unless Kohberger testifies, limiting its use in the guilt phase of the process. Ladies and gentlemen, the stage has been set. It's getting good. I keep looking at these rulings. And we'll give Bryan Kohberger the presumption of innocence. But the defense, although they don't have to prove anything, they have to be able to explain away why something was there, right? Oh, Bryan Kohberger went to this house all the time for parties. Nope, zero evidence of that. The knife sheath wasn't his DNA. Nope, they've all but conceded it's his DNA. This is a death penalty case, ladies and gentlemen. The attorneys are going into death mode. They've basically are conceding that they don't have a whole lot for trial. They're doing what they can, but this is now going into mitigation mode, trying to convince the prosecution to drop the death penalty. We'll keep you informed as it becomes available. Next, Karen Reed's second trial. The retrial started today with opening statements and witness testimony in the Massachusetts murder case. Now, Reed, who is accused of hitting her Boston police officer boyfriend, John O'Keefe, with her SUV and leaving him to die in the snow back in Canton, Massachusetts in 2022, is being retried less than a year after her first trial ended in a mistrial. Now, Miss Reed is charged with the second-degree murder, manslaughter while operating under the influence of alcohol, and leaving the scene of a personal injury or death. She's pled not guilty to all the charges and argues several people, including law enforcement, are framing her. 8 jurors, 9 men and 9 women, have been seated after the jury selection process, which took 10 days. One of the alternate jurors from Reed's first trial is also a member of her legal team. Weird. Anyway, the special prosecutor, Hank Brennan, the former Whitey Bulger attorney who was not part of the first trial, made his opening statement for the Commonwealth. Brennan started by setting the scene in Canton, describing how firefighters and paramedics Timothy Nuttall responded to 34 Fairview Road in near blizzard-like conditions and found O'Keefe in the snow without a pulse. He looked up at Miss Reed and he said, "What happened?" And you hear her words through firefighter Nuttall. She said, "I hit him, I hit him, I hit him." Brennan said in openings, "We are here today because John O'Keefe was killed by the actions and the conduct of the defendant, Miss Karen Reed," Brennan stated. Now, Brennan told the jury that the data from Reed's cell phone and car will be a key part of the prosecution's argument. In addition to the location information, Brennan said data showing the temperature of the cell phone battery will be critical to your analysis of this case, an element that wasn't raised during Reed's first trial. When it comes to Reed's SUV, Brennan suggested there is black box data that reveals different things than what were discussed in the first trial. He said she threw her Lexus into neutral and then reverse and put her foot on the gas pedal to 75% acceleration. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. Brennan also brought up angry voicemails that Reed left for O'Keefe after midnight. The prosecutor referenced a 12:59 a.m. message in which Reed says, "John, nobody knows where you are." And this is where the plot and the cover-up begins, Brennan says. The evidence will make clear that she knew he was there. She did not call 911. She did not go back to him. She did not leave an anonymous tip. She left him. Brennan ended by playing a clip from October of 2024, a Dateline interview with Miss Reed. Prosecutors say in a filing last week that they plan to use Reed's own words against her at trial, and it's expected that they will play clips from Reed's various media interviews that she has done in the most recent months. Quote, "I didn't think I hit him, but I could have clipped him. Could I have tapped him on the knee and incapacitated him? He didn't look mortally wounded as far as I could see," Reed says in the interview. "But could I have done something that knocked him out in the drunkenness and in the cold? He didn't come to again." Reed's lawyer, Alex Jackson, delivered his opening statement for the defense. During the last trial, it was attorney David Yannetti who was the first to speak on Miss Reed's behalf. Now, Jackson started by telling jurors that the evidence will establish that there was no collision with John O'Keefe. John O'Keefe did not die from being hit by a vehicle, period. He said, "The facts will show, that the evidence will show, that the data will show, that the science will show, that the experts will tell you that." Jackson said the investigation into O'Keefe's death was corrupted by bias, corrupted by incompetence, and corrupted by deceit. He blasted former Massachusetts State Trooper Michael Proctor, the lead investigator in the case, as a cancer who never went into the Fairview Road home owned by Boston police officer Brian Albert, or even canvassed witnesses. You'll see during the trial that he intentionally lied and fabricated evidence during the course of his investigation. He lied in reports, warrants. He lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why, Jackson asked? He lied because he did not want it revealed that he had access to the vehicle and that he had access to that taillight before any taillight fragments were found at 34 Fairview. At the end of his opening statement, Jackson asked the jury to find Reed not guilty on all three verdicts. After the first trial concluded, some jurors told the defense that they had agreed that Reed should have been acquitted on 2 charges, but weren't sure how to communicate that to the judge. "Not guilty, not guilty, not guilty," Jackson repeated. After the opening statements, prosecutors began to call witnesses to testify at trial. Canton firefighter and paramedic Timothy Nuttall, whom Brennan referenced in his opening statement, was the first to take the stand. He said the snow was coming down heavily when he arrived at 34 Fairview and followed the sounds of women screaming. He said he saw O'Keefe laying on his back and took his pulse. "I looked for any signs of breathing. I found none," Nuttall said. "He was very cold to the touch." While he was attending to O'Keefe, Nuttall said he looked up and saw a middle-aged woman with blood on her face. He identified her in the courtroom as Miss Reed. "I hit him, I hit him, I hit him," Nuttall recalled Reed saying. "I remember it very distinctly." He said he observed that O'Keefe had pretty good bump over his right eye and several notable deep scratches on his right arm. The defense had argued that O'Keefe's injuries came from a dog attack inside the Albert home and not from Reed's SUV. During cross-examination, Jackson asked Nuttall about his previous meeting with prosecutors and pointed out that Nuttall testified in the first trial that Reed said, "I hit him only twice." If you testified last year that you heard the phrase twice and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, aren't they? Mr. Jackson asked. Yes, sir. The firefighter responded. The next witness called to testify was Carrie Roberts, a friend of O'Keefe's who had helped Reed look for the boyfriend on the night that he died. But before Roberts testified, the prosecution played what appeared to be an unedited clip of a Reed media interview from the investigation Discovery docuseries. "I know I said I hit him, but did I really say it as many times as law enforcement claiming that I said?" Reed said in the video. Roberts testified about getting a frantic 5 a.m. phone call from Miss Reed. The first thing she said was, Carrie, John's dead," and she hung up the phone, Roberts said. Reed hung up, but called right back. The second time she said, "I think something happened to John. I think he got hit by a plow. He didn't come home last night," according to Reed. That's where the day ended. There are 150 names that the prosecution and the defense may call. Among those who played a major role in the first trial and could testify again are former Trooper Proctor, who was fired for his conduct while leading the Reed investigation, and Jennifer McCabe, who made the controversial "How's Long to Die in Cold" Google search. Also on the witness list are Brian Higgins, Brian Albert, Colin Albert. The defense has argued that they could have killed O'Keefe during the fight inside Brian Albert's home at 34 Fairview Road. And the judge, however, has ruled that the defense cannot argue that Colin Albert, who was a teenager at the time, could have been the one responsible for O'Keefe's death. Now, the trial schedule, we're going to bring it to you live, trial-to-trial coverage. The trial resumes again Wednesday at 9 a.m. Now, the first trial went for 29 days of testimony over nearly 2 months. The second trial may move a little faster. As the judge said, the court will be doing as many full days as possible as opposed to half days of testimony that were quite frequent in the first trial. Generally, the court will start at 9 a.m. They'll go till 4 p.m. Eastern time, obviously, and they'll take a short morning break about 11 a.m. as well as lunch break at about 1 p.m. I'm telling you that this is going to be good. The special prosecutor, Mr. Brennan, he's good. Really good opening statement. Already weaving in Karen Reed's own statements to be used against her, and just boom, hit play, right? Nice touch. Anyway, the defense also did a very good job on their opening statement. Remember, opening statements are not evidence. They're a roadmap of what the jury should expect to see the evidence come out as, but it was also very good. It was very good. So we have two very skilled attorneys on this particular case. I expect this to be a knockdown, drag-out fight, and it's going to be good. Well, we have Karen Reed, the presumption of innocence. I don't know how the jury will come out on this case. I'm going to watch it. I'm going to be watching it every minute that I can. I'll try to bring updates and commentary on it as well, but it's going to be good. Next, Scott Peterson. That's right. Convicted killer Scott Peterson has offered a moment-by-moment breakdown of the days surrounding his wife's disappearance as part of yet another new petition to overturn his conviction. Now, Peterson was convicted of murdering his wife, Lacey Peterson, and their unborn son, to be named Connor, who disappeared on December 24th, 2002. Now, Scott was sentenced to death for the murder in 2005, but in 2020, the death sentence was vacated, and he was resentenced in 2021 to life without the possibility of parole. Now, the Los Angeles Innocence Project has intervened in Mr. Peterson's case, and they filed a new petition seeking to overturn the 2004 conviction based upon new evidence and witness statements. The petition argues the new evidence undermines the prosecution's entire circumstantial case against Mr. Peterson and shows that the jury relied upon false evidence, including false scientific evidence, to convict him. Among the evidence referenced in the, wait for it, 854-page petition are details of a burglary at the home of the Medinas, the Petersons' neighbors. A witness who reported hearing the burglars talk about Lacey's seeing and confronting them, and evidence that the police intentionally destroyed evidence that could have linked the burglary to Lacey's disappearance and murder. Additional evidence from the Innocence Project outlines in the petition include evidence that the Medina's home was burglarized on December 24th, the day that Lacey disappeared, and not on December 26th, as the day the jury was actually informed. Evidence showing there was other involved in the burglary other than the two who pled guilty. Evidence directly linking the Medina's burglary to the orange van that was intentionally set on fire not far from the Petersons' home on December 25th. Scientific and medical research developed after Scott's conviction related to the fetal growth as it relates as to the timing of Lacey and Connor's death. New modeling showing Lacey and Connor's bodies could not have migrated from the area where Scott said he went fishing to where they were actually recovered, and new sworn statements from witnesses who described seeing Lacey walking the dog after Scott left their home on the morning of December 24th. Analysis of the police investigation showing that it was disorganized, failed to follow basic police procedures, and that the standard at the time was driven by confirmation bias. The petition includes a 129-page declaration written by Scott, which details not only his relationship with Lacey, but his activities in the days and hours before she disappeared. Scott described his marriage to Lacey as happy and loving, and the two worked together at the San Luis Obispo for several years before moving to Modesto to be closer to Lacey's family. The two fixed up their home together, and Scott said they were focused on preparing the nursery for Connor's arrival. Scott's declaration suggests that if it's not the burglars, some other unknown person must have killed Lacey, likely abducting her while she was out walking the family dog, whose name was Mackenzie. Lacey and I were getting increasingly concerned about the unsavory foot traffic we were seeing in our neighborhood street, Scott wrote. I would give anything to be able to go back in time and walk the dog with Lacey because I know she would still be alive and Connor would now be a young man. According to the declarations, Lacey was intent on keeping their neighborhood safe, and she was not shy about it, suggesting that she must have approached somebody on her own. Scott noted previously confirming a man who was looking over the Petersons' fence and going through their trash. Scott later identified that man as Stephen Todd, who confessed to the Medina burglary after the arrest. Todd has never been named as a suspect in Lacey's disappearance or murder. Scott tried to explain much of the evidence prosecutors used at trial as evidence of guilt, including the mess of concrete found in his workshop. Prosecutors said that Scott had been making concrete anchors to weigh Lacey's body after dumping her off in his fishing boat into the San Francisco Bay. But Scott says that while, yes, he had made anchors for the new boat he and Lacey purchased, the concrete mess was actually a result of projects he was working on, including a table for Lacey. Now, while Scott repeatedly professed his love for Lacey and described their marriage as happy in the declaration, he does admit on page 125 that he was having an extramarital affair at the time of his wife's disappearance. We'll see if he's going to get that new trial, ladies and gentlemen. One of the things about criminal law is obviously we don't want innocent people to remain in custody. But at a certain point, you got to say it's over. And you have to say it's some information that was not available at the time of the trial for this newly discovered evidence. But you also can't have these post-convictions that are successive, basically saying, well, if that didn't work, then this. Well, if that didn't work, then this. The law is not set up to be like that. There has to be some finality. But my guess is it's California. He will more than likely get a retrial, I don't know, in the next 2 years or so. I guess write it down. We'll see if I'm right. Next, schools should not be a fight club. Down in Florida, a Hendry County substitute teacher is facing felony charges accused of helping set up a fight between students. And guess what? It was all caught on video inside a classroom. In the censored video, the Hendry County Sheriff's Office shared what you can see as a student gets pushed into a desk while others watch. Deputies said this happened Tuesday inside La Bella Middle School classroom while 20-year-old substitute Taisha Holmes was in charge. They said she let one of the students call the front desk to have another girl sent to her room, knowing a fight might happen. A student recorded the whole thing, and the sheriff's office said a parent found out about the video the next day on her daughter's phone and reported it. The sheriff says that Holmes was arrested for 2 counts of child neglect and 8 counts of contributing to delinquency of a minor, and she was ultimately released on a $35,000 bond. Of course, the school district goes into panic mode, saying, hey, she was a substitute teacher, passed all the background checks, but now, guess what? We're going to make sure that this never happens again. She's been fired and will never come in contact with children ever again, at least not as a teacher. Next, this day in legal history, on April 22nd, 1889, the Oklahoma land rush begins, sparking a legal dispute over the land claims and the Native American rights, shaping Western property law. On this date, April 22nd, 1903, the Supreme Court hears Lone Wolf v. Hitchcock, later affirming Congress's authority over Native American treaties, a landmark tribal law case. On this date in 1947, the Supreme Court hears Everson v. Board of Education, later affirming the separation of church and state, a key First Amendment ruling. On this date in 1963, Gideon v. Wainwright ruling impact expands with states implementing public defender systems, reinforcing the right to counsel. And on this date in 2005, the United States Supreme Court hears Roper v. Simmons, later banning the death penalty for juveniles. Obviously, a big milestone there in juvenile justice reform. And then finally today, our dumb criminal of the day. An Orange County man was arrested there in Florida, accused of impersonating a police officer and trying to pull over another vehicle. Deputies say that Albert Dolan followed a vehicle along the Stony Brook Parkway near the State Road 535 for about a mile with amber lights flashing from the car. The driver thought the black car was an unmarked police car, so she pulled over. The police deputies added that Dolan approached the victim on the driver's side of the vehicle and asked for a driver's license. When the driver asked why, he's told Dolan that he was going to get a speeding ticket. According to the sheriffs, though, the victim said Dolan refused to show his ID or badge and then let him go. The driver then called 911 and provided Dolan's license plate number. When the deputies arrived, they arrested Mr. Dolan. They said he uttered that, quote, he did not impersonate a deputy, according to the police deputies, end quote. Anyway, the sheriff's office said that Mr. Dolan has a history of buying former police vehicles with lights and sirens still attached, and that he had been accused of impersonating a police officer once before. Back in September of 2017, it was reported that Dolan was accused of posing as a police officer and driving with red and blue lights activated on a black Dodge Charger, speeding through an intersection. According to that arrest affidavit, when a Winter Garden police officer stopped the car, Dolan claimed he worked for the Florida Department of Law Enforcement, as well as the Drug Enforcement Agency. Then in 2018, according to the Orange County Court records, Dolan was out on bond. He was arrested by the Orlando police on charges of impersonating a law enforcement officer. Yet again, guess what? He ultimately went to prison for 5 years. Needless to say, Mr. Dolan is currently in the Orange County Jail, where he cannot pretend to be a police officer. Mr. Dolan, hope you get the help that you need. I don't understand the need to pull people over and act like a police officer. But sir, you are our dumb criminal of the day. Congratulations, you made it. All right, everybody, thanks for watching. We'll see you next time. Remember, the Constitution matters.